recognize Representative Waller for opening remarks on House File 2555.
Thank you, Mr. Chair. House File 2555 relates to license plate readers. License plate readers are an incredible tool for law enforcement. Even small numbers of them can dramatically increase the chance of solving crimes ranging from property crime to human trafficking to Amber Alerts, even to a murder that involved a vehicle found with these things near where I live in the rural part of the county. Just as we did with the DNA bill, if we're serious about solving crime and taking on crime, we need to give law enforcement the tools to do that. So this bill seeks to balance Fourth Amendment concerns, privacy concerns, with the need for these tools. Those are my opening comments.
Is there discussion? Chair recognizes Representative Pat Grassley.
Thank you, Mr. Chair. I think there have been 3 different bills filed on this topic this week, so I think we've all tried to become experts as quickly as we can, and I don't know that we are experts, but I think this is a good synthesis of what we've seen. I think it's a good balance between public safety and individual rights, so I urge everybody to support this good compromise.
Thank you. Is there any further discussion? Chair recognizes Mr. Thompson.
Thank you, Mr. Chairman. I support this bill. I think it's a good start in getting a good regulatory scheme in the state and put us in the lead among other states.
Thank you. Is there any further discussion? Seeing none, the chair recognizes Representative Waller for closing remarks on House File 2555. Representative Waller moves House File 2555. Clerk will call the roll.
Representative Cole.
Aye.
Representative Waller.
Aye.
Representative Blumer.
Aye.
Representative Bagasi.
Aye.
Representative General.
Aye.
Representative Pat. Aye. Representative Grassley.
Aye.
Representative Norman.
Aye.
Representative Ramirez.
Aye.
Representative Shipley.
Aye.
Representative Shrivas.
Aye.
Representative Stone.
Aye.
Representative N. Thompson.
Aye.
Representative C. Thompson.
Aye.
Representative Watkins.
Aye.
Representative Wessel Rochelle.
Aye.
Representative Wheeler.
Aye.
Representative Wickendall.
Aye.
Representative Williams.
Aye.
Representative Wills. Unanimous.
With unanimous vote, House File 2555 removed from the floor as a committee bill. If there are no objections at this time, I will turn the chair over to Representative Waller.
Chair recognizes Representative Holt for opening comments on House File 668.
Thank you. House File 668 creates a presumption that the person reasonably believed the use of force was necessary for defense of self, another person, or property from what the person reasonably believed to be an imminent threat from another person. Law enforcement will only arrest if there is a probable cause to believe that the force that was used was unlawful. It further provides that when a justified use of force immunity has been raised by a person in a pretrial immunity hearing, the burden of proof by clear and convincing evidence is on the state. There are still a number of ongoing discussions with county attorneys regarding a number of concerns on this legislation, so we will see where it goes from here. But I'm extremely concerned about this particular issue because I think there have been some lives ruined because this wasn't looked at on the front end. So that is what is behind the legislation. That concludes my opening remarks.
Thank you. Is there further discussion? Chair recognizes Representative Rochelle.
Thank you, Mr. Chair. I was a little surprised to see this on the agenda today because it was my understanding from subcommittee that it needs a lot of work. It's a pretty big bill, and I would like to see that work done before actually voting on it. In my estimation, it will make accountability harder in questionable shootings or violent encounters, and therefore today I am a no vote. Thank you.
Thank you. Seeing no further discussion, the chair recognizes Representative Holt for closing remarks.
Thank you, Representative Russell Cushell. There were a lot of concerns raised, and so I continue to discuss those concerns with county attorneys and others. But I am aware of situations in which there was a justified use of force, but the person was still arrested and had their lives ruined. And so that is why we're going to see what we can do to address this. Having said that, I move House File 668.
Representative Holt moves House File 668. Clerk will call the roll.
Representative Cole.
Aye.
Representative Waller.
Aye.
Representative Blumer.
No.
Representative Bagasi.
Aye.
Representative General.
Aye.
Representative Pat.
Aye.
Representative Grassley.
Aye.
Representative Norman.
Aye.
Representative Ramirez.
No.
Representative Shipley.
Aye.
Representative Shrivas.
No.
Representative Stone.
Aye.
Representative N. Thompson.
Aye.
Representative C. Thompson.
Aye.
Representative Watkins.
Aye.
Representative Wessel Rochelle.
No.
Representative Wheeler.
Aye.
Representative Wickendall.
No.
Representative Williams.
Aye.
Representative Wills.
Aye.
15-5.
Opposed, 15 ayes and 5 nays, and the bill is approved. House File 668 moves with the House Floor Committee Bill. The chair recognizes Representative Holt for opening comments on House Study Bill 722.
Thank you, Mr. Chair. This legislation makes significant changes to the magistrate system here in Iowa. It is an initiative of the Judicial Branch. The existing system for magistrates has been in place for over 40 years. The current system mandates a specific number of magistrates, and with the massive changes that have been made in technology in recent times, with warrants now being done remotely, changing to a more efficient cost-saving system seems to make sense. The legislation shifts magistrate appointments from individual counties to judicial election districts. It removes the statutory number of magistrates per county, authorizing the Supreme Court to develop a formula based on workload to allocate magistrates among judicial election districts. It changes the magistrate appointing commission membership and eliminates the requirement for public notices of magistrate vacancies in county newspapers. It establishes the role of senior magistrates for retired magistrates, meeting age and service requirements. It sets rules for senior magistrate compensation, including salary, reimbursement, and medical insurance, and provides for the removal or voluntary relinquishment. It raises judicial officer salaries by 5% in June 2027 and sets magistrate compensation at 40% of district associate judge salaries. And it appropriates funds for these increases and enacts most of these changes on November 1st, 2026. This concludes my remarks.
Thank you. Is there discussion? Representative Williams.
Thanks, Mr. Chair. I rise in support of the I'm sitting in support of this. Yeah, I mean, there needs to be some updates. Even those who express concerns about this, there should be a plan for about how to do this. I'm eager to hear what some of the alternatives might be, but we support particular increasing that pay, and we'll move forward with this.
Thank you. Seeing no further discussion, the chair recognizes Representative Holt for closing remarks.
Thank you. To Representative Wilbur's point, there's a great deal of concern from legislation from our magistrates and from some others. I'm going to continue to gather information, listening to all of those concerns. I welcome input from everyone as we work to make our judicial system as responsive and efficient as possible in the administration of justice. Again, I welcome suggestions from the Magistrate Association and from others on how we can make the system better and what changes they would recommend to this legislation. Mr. Chair, I move House Study Bill 722.
Representative Holt moves House Study Bill 722. Clerk will call the roll.
Representative Holt.
Aye.
Representative Waller.
Aye.
Representative Wilbur.
Aye.
Representative Pat Grassley.
Aye.
Representative Dunlop.
Aye.
Representative Beck. Aye. Representative Gustaf.
Aye.
Representative Norman. Representative Ramirez. Aye. Representative Shipley.
Aye.
Representative Srinivas. Representative Stone.
Aye.
Representative N. Thompson.
Aye.
Representative C. Thompson.
No.
Representative Watkins.
Aye.
Representative Wesson Rochelle. Aye. Representative Wheeler.
Aye.
Representative Wickendall. Aye. Representative Williams.
Aye.
Representative Wills.
Aye.
18-2.
Vote is 18 ayes and 2 nays, and the bill is approved. House Study Bill 722 moves to the House floor as a committee bill. The chair recognizes Representative Holt for opening comments on House Study Bill 616.
Thank you, Mr. Chair. This legislation is in response to a Supreme Court decision to change what had been standard practice for decades regarding payment of court costs. The language seeks to return to the status quo for pecuniary damages. This language is by no means a done deal. I've been speaking with the ACLU on some concerns they have about how the language is written, so it will not be the final language, but I just did not have a chance before this committee to nail that completely down. So it will need to be revised before it comes to the floor, and I would welcome input from interested stakeholders. This will not be the final language, but this will be the vehicle in which we will hopefully get this fixed. This concludes my opening remarks.
Is there discussion? Representative Gagneski.
Thank you, Mr. Chair. I echo Representative Holt's statement. I think there is still some work to be done on this, but I look forward to getting it to the floor. I urge everybody to support it.
Seeing no further discussion, chair recognizes Representative Holt for closing remarks. Representative Holt moves House Study Bill 616. Clerk will call the roll.
Representative Holt.
Aye.
Representative Waller.
Aye.
Representative Wilburn.
Aye.
Representative Bagneski.
Aye.
Representative Dunlop.
Aye.
Representative Beck. Aye. Representative Gustaf.
Aye.
Representative Norman.
Aye.
Representative Ramirez. No. Representative Shipley.
Aye.
Representative Srinivas.
No.
Representative Stone.
Yes.
Yes. Representative Stone.
Aye.
Representative N. Thompson.
Aye.
Representative C. Thompson.
Aye.
Representative Watkins.
Aye.
Representative Wesson Rochelle. Aye. Representative Wheeler.
Aye.
Representative Wickendall. Aye. Representative Williams.
Aye.
Representative Lewis. 19-1.
With a vote of 19-1, the bill is approved. House Study Bill 616 moves to the House floor as a committee bill. The chair recognizes Representative Holt for opening comments on House Study Bill 738.
Thank you, and some of you may be asking what the heck, so I'll explain this. I submitted this bill after speaking with some county supervisors, who were advised by their county attorney that language in the code was so vague that it was uncertain whether the county supervisors could discipline and or terminate a road assessor or an assessor in violation of employment standards or engaging in unethical conduct. Clearly, assessors must be protected from retaliation related to assessments, but all of us have to answer to someone. And in the case of the assessor, it would seem to me that they should answer to the body that appointed them, but the language in the code is very vague, and this is becoming a problem. So I would say, just like the last bill, this language is a work in progress. I've reached out to the Assessors Association. Hopefully they'll be getting back to me. But the whole point here is to make sure that assessors, like everybody else in government, can be held accountable for unacceptable conduct, like lavish vacations or abusing taxpayers, this sort of thing. That's what we're trying to get out of here. That concludes my opening remarks.
Is there discussion? Representative Holt.
Yes, thanks, Mr. Chair. I did serve on this subcommittee, and in general, in support of the bill. I do believe the phrase applicable employment standards might be a little too broad, but overall, I agree with the concept of the bill and will recommend yes.
Thank you. Is there further discussion? Seeing none, chair recognizes Representative Holt for closing remarks.
And I'm certainly open to fixing that. Like I said, this is not a done deal. I'm just trying to make sure that people that are abusing the system are held accountable for the taxpayers. With that, House Study Bill 738.
Representative Holt moves House Study Bill 738. The clerk will call the roll.
Representative Holt.
Aye.
Representative Waller.
Aye.
Representative Hilbert.
Aye.
Representative Pat Grassley.
Aye.
Representative Dunlap.
Aye.
Representative Fett.
Aye.
Representative Duffel.
Aye.
Representative Norman.
Aye.
Representative Ramirez. Aye. Representative Shinley.
Aye.
Representative Srinivas.
Aye.
Representative Stone.
Aye.
Representative N. Thompson.
Aye.
Representative C. Thompson.
Aye.
Representative Watkins.
Aye.
Representative Wesson Michelle.
Aye.
Representative Wheeler.
Aye.
Representative Wickendall.
Aye.
Representative Williams.
Aye.
Representative Williams. Unanimous.
With unanimous vote, the bill is approved. House Study Bill 738 moves to the House floor as a committee bill. The chair turns the chair back to the committee.
Thank you. At this time, the chair recognizes Representative Wills for opening remarks on House File 2413. Excuse me, Representative Waller for opening remarks on House File 2413. Were you ready, Representative Wills? Did I wake you up?
I was gonna give a little break there. This bill, House File 2413. The purpose of this bill is to reestablish accountability for major rules created by bureaucrats and agencies that impose large costs on Iowans, whether it's in their personal lives or in their businesses. So the goal is to cut red tape, fight hidden taxes, fight inflation caused by bureaucrats. There's an amendment.
There is an amendment. The chair recognizes Representative Waller for opening remarks on Amendment 2750.
The amendment creates exceptions to the major rule requirement for regular summer E15 waivers and for regular IPERS contribution changes. Those are my remarks on the amendment.
Is there discussion on the amendment? Seeing none, Representative Waller, you recognize for closing remarks on Amendment 2750.
I move.
Representative Waller moves Amendment 2750 in full form. All those in favor signify by saying aye.
Aye.
All those opposed say no. The ayes appear to have it. The ayes you have it. The amendment is adopted. We are now back on House File 2413 as amended. Is there further discussion? Chair recognizes Representative Bagneski.
Thank you, Mr. Chair. I'm glad to see that we put forth an amendment for IPERS on this bill. My concern is, are there other programs, are there other expenditures that we're not thinking of that we didn't catch? In that vein, my remarks at subcommittee were that I was concerned that we're restricting government's ability to respond to crises and natural disasters, whether it's avian flu or a terrorist attack or a natural disaster, an attack on the food supply, a farm mortgage crisis, God forbid. What are we doing to ourselves with this legislation? Have we thought through every potential avenue that we might have to deal with? And in fairness, I want to say that this bill does have provisions in there that the governor would have some powers to have a temporary decision that would be ratified by the legislature. My concern is, you know, the bargaining power for that governor might be somewhat limited if any decision they make or any deal that they have with public or private actors could be overturned just a couple months later. So I think that there's still a lot left to be answered in this bill. I hope we continue to work on it if we go forward, but I would urge my caucus to oppose it.
Thank you. Is there any further discussion? Seeing none, the chair recognizes the law for closing remarks on House File 2413 as amended.
I appreciate the comments from Representative Bagnesky, as he recognizes there is a provision in the bill that attempts to address that provides for coordination by the governor with the legislative council. I would also note that this bill has been passed by other states, including Florida 16 years ago, Wisconsin almost a decade ago, so they've handled crises like COVID already under this regime. That concludes my remarks.
Representative Belin moves House File 2413 as amended. Clerk will call the roll.
Representative Holt.
Aye.
Representative Walker.
Aye.
Representative Wilbur.
No.
Representative Bagnesky.
No.
Representative Dunlop.
Aye.
Representative Beck. Aye. Representative Guston.
Aye.
Representative Morgan.
Aye.
Representative Ramirez.
No.
Representative Shipley.
Aye.
Representative Trinivaus. No. Representative Stone.
Aye.
Representative N. Thompson.
Aye.
Representative C. Thompson.
Aye.
Representative Watkins.
Aye.
Representative West Rochelle. No. Representative Wheeler.
Aye.
Representative Wickendall. No. Representative Williams.
Aye.
Representative Wills.
Aye.
14-6.
The vote is 14-6. House File 2413 as amended will move to the floor as a committee bill. The chair recognizes Representative M. Thompson for opening remarks on House File 2144.
House File 2144 allows victims of human trafficking to petition for expungement of their criminal records for offenses committed while they were victims of human trafficking. The bill sets forth procedures for filling out those petitions. It also does not include serious felonies. That is not included in here. In other words, if the victim was compelled to shoplift, if the victim was compelled to do credit card fraud, something of that nature, she or he can appeal that crime. Should be mentioned that only a handful of other states have not passed this bill. We're in the distinct minority there, and other folks have done that. The two victims that I had, frankly, the honor to be with this summer, one was from Florida, one was from Wisconsin. The one from Florida had a much easier time getting back in the workforce, getting settled, getting her life back on track, slowly but surely. The one from Wisconsin had a much more difficult time. This bill sets forth a procedure to make sure they're taken care of. Thank you.
Is there discussion? Chair recognizes Mr. Wilbur.
Yes, I recommend a yes on this so that folks that find themselves in these circumstances have an option. I do think it's important that we make sure that there is indigent defense, because if someone were to try to do a petition on their own and end up making a mistake, could end up with a Class D felony for applying under a false pretense. So recommend yes.
Any further discussion? Seeing none, the chair recognizes Representative Thompson for closing remarks on House File 2144.
I move the bill.
Representative Thompson moves House File 2144. Clerk will call the roll.
Representative Holt.
Aye.
Representative Waller.
Aye.
Representative Wilbur.
Aye.
Representative Bagnesky.
Aye.
Representative Dunlop.
Aye.
Representative Beck.
Aye.
Representative Guston.
Aye.
Representative Morgan. Representative Ramirez. Representative Shipley. Representative Trinivaus. Representative Stone. Representative N. Thompson. Representative C. Thompson. Representative Watkins. Representative West Rochelle. Representative Wheeler. Representative Wickendall. Representative Williams. Representative Wills.
Unanimous vote. House File 2144 will move to the floor as a committee bill. The chair recognizes Representative Guston for opening remarks on House Bill 570.
Thank you, Mr. Chairman. This is a bill that comes to us from the Attorney General. And along with it, I'll distill it down to this. It makes several victim protection updates, especially of sexual abuse victims. Victim counsel, it clarifies and strengthens victim counsel confidentiality and privilege. That's a good faith community exemption for disclosure made in the statute. It modifies protective orders for victims of particular sexual extended, including victim lasts for any length of time up to a victim's lifetime. Sex offender registration tightens deadlines and adds in-person reporting requirements, extends retention of sexual abuse evidence kits for 20 years with a lifetime of minor victim, and adds notice provisions before those are even disposed of. Competency and civil commitment hearings have some revision here to have clearer timelines, procedures for independent evaluations, when restoration is unlikely. We do reclassify some victim compensation program reimbursement in here, and then there's some updates to sexual assault examiner training and oversight to align with the Department of Justice guidelines. Those are my opening comments.
Representative Gustaf, is there an amendment?
There's not an amendment. There's none. Oh, is this one strike section 15? Yes. Sorry.
So let me recognize you for amendment 2750.
2630.
Excuse me, yeah, amendment 2630.
Yes, I'm sorry, it strikes section 2630, strikes section 15, unnecessary reference to the victim crime and compensation program.
Thank you. Is there discussion on amendment 2630? Chair recognizes Representative Ramirez.
Thank you, Mr. Chair. I'm in support of this amendment.
Thank you. Is there any further discussion? Seeing none, Representative Gustaf moves amendment 2630 short form. All those in favor signify by saying aye. Aye. All those opposed say no. The ayes have amendment 2630 is adopted. We are now back in House Study Bill 570 as amended. Is there further discussion? Chair recognizes Representative Ramirez.
Thank you, Mr. Chair. I'll be honest, there's a few elements of this bill that's really, really great. I think particularly Division 4 outlines a lot of the elements that Representative Gustaf described, it keeping the sexual abuse kits for longer, notifying victims of disposal of kits. All of these are really great things. I wish this was a standalone bill. Unfortunately, what we saw at our subcommittee was countless victim service providers flagging that this bill will actually, as it stands, will actually harm victims. I had the Iowa Coalition of Domestic Violence reach out to me. They represent 25 victim service providers that work directly with victims of sexual violence and domestic violence. They are registered against this bill and describe that the confidentiality component of the victim counselors Division 1 section would require victim counselors to disclose client information without victim consent. So I wanted to share a few of their thoughts as well as my own. For victims of sexual assault and domestic violence, human trafficking, the decision to seek help is very difficult and it comes at great personal risk. As you can imagine, as a service provider, all of the calls that you're yielding are dealing with very, very high-risk situations. That is the very nature of their job. So having the provision to say that now you should and you have full ability to make these calls to law enforcement based off of what your clients then told you, it doesn't give the assurance that an advocate needs to be able to safely help a victim. This confidentiality is what allows survivors to be honest about their circumstances and then be able to find a path forward. We heard from victim service providers that although they recognize the intent is to help victims, that's not actually going to be the outcome of what happens. From the Iowa Coalition of Domestic Violence, I want to quote them. Quote, we recommend the provisions in House Study Bill 57, page 2, lines 23 through 25, page 2, lines 24 through 36, page 3, lines 1 through 6, altogether and simply amending a different code section, i.e. any new state exceptions to victim confidentiality without client consent are unnecessary and harmful. Without confidentiality, many victims will avoid seeking help or limit the information they disclose, which makes it harder to help them. Training is a more effective and appropriate way to prepare victim counselors for navigating escalating threats to safety. A redundant and less precise provision layered on top does not strengthen protections. It introduces conflict, invites inconsistency, and creates conditions where efforts to help could cause harm instead. Finally, the information for which disclosure is sought to be compelled is the victim's information. The victim and the victim alone should be allowed to decide whether that information should be disclosed and
quite a lot of work, given that I think the intent of the bill was to help victims and survivors and victims alike, but as it stands, it would do the exact opposite and put victim counselors in a uncomfortable position where they would then be having to elevate their calls to law enforcement or feel the need to and create that pressure, and then victims would be harmed. There's some other concerns that were flagged in other divisions, specifically around mental competency division, and then also I had some nurses, I think, reached out to some of us members on the subcommittee that were concerned about Division 7. They shared some concerns around the change of the guidelines and felt that it would weaken standards and make them duplicative. Long story short, I would love for us to continue working on it if we proceed to move this bill forward, but I would recommend a no at this time.
Thank you. Is there any further discussion? Seeing none, the chair recognizes Representative Gustav for closing remarks on House Bill 570 as amended.
Thank you, I appreciate those comments, I appreciate the input from the subcommittee and following from different groups. So it's not uniformly opposed, this language, the request to change here came from, among others, we asked the Attorney General's office, where did this come from, what was the issue? Family Crisis Center in Sioux Center, Family Resources in Davenport, Crisis Intervention Services in Mason City, dozens of victim advocacy councils around the state, they have roundtable discussions with, so it's not uniformly opposed by those in the field. And I dug in, did some research on my own as to what other professions. The disclosure here is required upon imminent risk of serious physical injury or death to the victim or another person. That makes it consistent in line with what lawyers deal with under Rule 32 of our professional. Representative Thompson, Representative a lot of our lawyers, we have the ethical obligations. This is Representative Bagnuski. Representative Shrivas is a doctor, and under Iowa Code Chapter Section 228.6, there are similar disclosure requirements if there's risk of imminent threat or death. And healthcare providers deal with this under Iowa Code Chapter Section 147.111. So I don't see this as out of the norm. It's consistent. And those are just three professions I looked up, but it's consistent with other professions out there. It's not requiring broad disclosure of all kinds of discussions, only in limited circumstances that there's risk of serious physical injury or death to the victim or another person. I think it's a good bill. It's a great tool. There's some work that needs to be done on it, and we'll continue working on it with that in the bill.
Thank you. And Lisa and Laura, I would like to talk to you along with the Representative Gustav between now and when it comes to the floor. Okay. Thank you. Okay. Representative Gustav moves House Bill 570 as amended. Call.
Representative Bolt.
Aye.
Representative Waller.
Aye.
Representative Blumer.
No.
Representative Bagnuski.
Aye.
Representative Dunlop.
Aye.
Representative Beck.
Aye.
Representative Gustav.
Aye.
Representative Norman.
Aye.
Representative Ramirez.
No.
Representative Shipley.
Aye.
Representative Srinivas. No. Representative Stone.
Aye.
Representative N. Thompson.
Aye.
Representative C. Thompson.
Aye.
Representative Watkins.
Aye.
Representative Westbrook Rochelle.
No.
Representative Wheeler.
Aye.
Representative Kendall.
Aye.
Representative Williams.
Aye.
Representative Wills.
Aye.
Thank you. With a vote of 16 to 4, House Senate Bill 570 as amended moves to the floor as a committee bill. Chair recognizes Representative Gustav for opening remarks on House File 8540.
Thank you, Mr. Chairman. This would be more appropriate on Groundhog's Day because we've seen this bill before. In fact, in the 90th General Assembly, we passed this through this committee and passed it through the House chamber 90-60, and it got stalled in the Senate. We passed it last year through the committee, and we need to take it up on the floor with the Russian at the end. This bill would require a de novo review if somebody violates rules that are promulgated by the department after we pass a law, and their ALJ, their own internal judge determines that yes, indeed, there's a violation of rules, and it's appealed to the district court. This would require a de novo review of the law, which in my mind is the judiciary's obligation to look at the law, and not just defer to what somebody in a department who's not elected nor a judicial officer of the court has determined the law means. Those are my comments. My opening comments.
Is it discussed? Chair recognizes Representative Wilbur.
I'm going to break that Groundhog's Day and being out. I did express concern before that there may be circumstances where The court doesn't necessarily have the expertise in a particular area, and it may create potentially some backlogs and some decisions. So I'll be in.
Is there any further discussion? Seeing none, the chair recognizes Representative Gustaf for closing remarks on House File 85-3.
Thank you, Mr. Chairman, and thank you, Representative Wilbur, for sitting in short notice on the subcommittee with that too. And I'm working with a couple of organizations about licensing issues in particular, and being able to defer to their expertise on that. So that's a point well taken, and so there probably will be some sort of amendment to this on the floor. Thank you. With that, I do that.
Representative Gustaf moves House File 85-3. Clerk will call the roll.
Representative Wolf.
Aye.
Representative Waller.
Aye.
Representative Blumer. Representative Magnuson.
No.
Representative Dunlop.
Aye.
Representative Fett.
Aye.
Representative Gustaf.
Aye.
Representative Norman. Representative Ramirez.
No.
Representative Shipley.
Aye.
Representative Trinados.
No.
Representative Stelton.
Aye.
Representative N. Thompson.
Aye.
Representative C. Thompson.
Aye.
Representative Watkins.
Aye.
Representative Wessel Rochelle.
No.
Representative Leavitt.
Aye.
Representative Wickendall.
No.
Representative Williams.
Aye.
Representative Wills.
Aye.
14-6.
Thank you. The vote of 14-6, House File 85-3 will move to the floor as a committee bill. The chair recognizes Representative Fett for opening remarks on House File 2436.
Thank you, Mr. Chair. House File 2436 updates Iowa's divorce statute to limit what name changes can be granted directly in a decree. Under the bill, the person may only return to the birth name or the name they used immediately before marriage as part of the divorce. Mr. Chair, there's an amendment.
There's an amendment. The chair recognizes Representative Fett for opening remarks on Amendment 2654.
The amendment is just a corrective amendment that strikes clerk of court and replaces it with court. Those are my opening remarks.
Is there discussion on the amendment? Seeing none, Representative Fett moves Amendment 2654 short form. All those in favor signify by saying aye.
Aye.
All those opposed say no. The ayes are passed. The ayes have the amendment is adopted. We're now back on House File 2436 as amended. Is there further discussion? Chair recognizes Representative Magnuson.
I don't know that either of us knew that this was an issue before the subcommittee, but it appears that it is. I think this is a common sense proposal to hopefully deal with it, and I urge you to support this measure.
Thank you. Any further discussion? Seeing none, Representative Fett, you recognize for closing remarks on House File 2436 as amended. Representative Fett moves House File 2436 as amended. The clerk will call the roll.
Representative Wolf.
Aye.
Representative Waller.
Aye.
Representative Blumer.
Aye.
Representative Magnuson.
Aye.
Representative Dunlop.
Aye.
Representative Fett.
Aye.
Representative Gustaf.
Aye.
Representative Norman. Representative Ramirez. Representative Shipley. Representative Trinados. Representative Stelton. Representative N.
Aye.
Representative C. Thompson. Representative Watkins. Representative Wessel Rochelle. Representative Leavitt.
Aye.
Representative Wickendall. Representative Williams. Representative Wills. Unanimous.
With the unanimous vote, House File 2436 will move to the floor as a committee bill. The chair recognizes Representative C. Thompson for opening remarks on House Senate Bill 631.
Thank you, Mr. Chairman. This bill is to mandate that the state court administrator collect and publish certain information related to performance of district judges. Most of the information that already exists in the computer systems, but is not readily available to the public. A number of questions have been raised about this, so this is not a finished product. Two of the big questions that we're working on, should this pass, would be making sure as much as possible that the public viewing these statistics understand that not every case is the same. In fact, there are wild disparities between the complex cases and the simple cases, and the numbers don't always tell the story. The other, I'm not sure whether it would be in this bill or another bill that is pending before us, involves security for judges and members of the judicial branch. I believe that is critically important, so we have to get that right. In the event those concludes my opening remarks.
Is there discussion on House Senate Bill 631? Going once, going twice. Chair recognizes.
In all fairness to me, this is what I had to sit in on. So, 631. Oh, thank you. Okay, thank you for the reminder. So I'm going to be no, recommend a no on this. I understand the importance for the judicial officer performance review. However, I think there needs to be a clear referral to the department as to what information should be reviewed. I need to see us 1 year from now or 2 years from now, see a report, and folks still don't have their questions. So if you have questions about what you'd like to see on performance review, it should be, the director should be giving us what that information is. Right now, we just don't know what it would be, so I'm a no because of that reason.
Thank you. Any further discussion? Seeing none, the chair recognizes Representative Thompson for closing remarks on House Senate Bill 631.
Yes, I welcome those remarks and look forward to working on the bill further. I would like to move the bill at this time.
Representative Thompson moves House Senate Bill 631. The clerk will call the roll.
Representative Cole?
Aye.
Representative Lawler?
Aye.
Representative Wilbur?
No.
Representative Pat Grassley?
No.
Representative Dunlap?
Aye.
Representative Beck? Aye. Representative Gustav?
Aye.
Representative Norman? Representative Ramirez? No. Representative Shipley?
Aye.
Representative Trinables? No. Representative Stone?
Aye.
Representative N. Thompson? Representative E. Thompson?
Aye.
Representative Watkins?
Aye.
Representative Wessel Rochelle?
No.
Representative Wheeler?
Aye.
Representative Wiggindall?
No.
Representative Williams?
Aye.
Representative Wills?
Aye.
14-6.
Thank you. With a vote of 14 to 6, House Senate Bill 631 will move to the floor as a committee bill. The chair recognizes Representative Stone for opening remarks on House Senate Bill 741.
Thank you, Mr. Chair. There is an amendment.
There is an amendment. The chair recognizes Representative Stone for opening remarks on Amendment 2747.
Thank you, Mr. Chair. Amendment 2747 is a strike after amendment relating to interviews conducted with a child subsequent to a reported child abuse. This concludes my comments on Amendment 2747.
Is there discussion on the amendment? Chair recognizes Representative Ramirez.
I support this amendment.
Thank you. Is there any further discussion on the amendment? Seeing none, Representative Stone moves Amendment 2747 short form. All those in favor signify by saying aye.
Aye.
All those opposed say no. After that, the ayes have it. The amendment is adopted. We're now back on House Senate Bill 741 as amended. Is there discussion? Chair recognizes Representative Ramirez.
Thank you, Mr. Chair. I have a few concerns prior to the amendment, but I do believe that the amendment makes our code a little bit more specific, makes the process a little bit more specific for what happens when police need to get involved in a child abuse case. I would be interested in working with Representative Stone on fine-tuning some of the language if there's interest there. I had heard that the law enforcement was concerned they don't want to become social workers, right? They have other jobs to do, so there's some language in there that I'd be interested in shifting just to make sure that that goal is being met. However, I'll be a yes at this time. Thank you.
Thank you. Thank you. Thank you. Any further discussion? Seeing none, Representative Stone moves House Senate Bill 741 as amended. The clerk will call the roll.
Representative Cole?
Aye.
Representative Lawler?
Aye.
Representative Wilbur?
Aye.
Representative Pat Grassley?
Aye.
Representative Dunlap?
Aye.
Representative Beck? Aye. Representative Gustav?
Aye.
Representative Norman?
Aye.
Representative Ramirez?
Aye.
Representative Shipley?
Aye.
Representative Trinables? Representative Stone?
Aye.
Representative N. Thompson? Representative E. Thompson?
Aye.
Representative Watkins?
Aye.
Representative Wessel Rochelle?
Aye.
Representative Wheeler?
Aye.
Representative Wiggindall? Representative Williams?
Aye.
Representative Wills?
Aye.
Unanimous.
With a unanimous vote, House Senate Bill 741 will move to the floor as a committee bill. At this time, the chair recognizes Representative Beck for opening remarks on House File 2574.
Thank you, Mr. Chair. House File 2574 is a bill that bars a court from deferring judgment or sentencing when the defendant was a public employee or a public official at the time of an offense involving the theft or misappropriation of public funds, and the amount taken from the public employer exceeds $10,000. Those are my opening remarks.
Is there discussion? Chair recognizes Representative Wilbur.
Thank you, Mr. Chair. I support this measure given some recent theft issues involving public employees. There's a higher degree of trust expected by and honesty by the public, whether you're elected or appointed, hired. The clear and convincing standard is higher than the preponderance of evidence, so that also would be a signal to the public that if you get elected, if you take these jobs, you got to take this seriously or get trained so that you know what you're doing. It's not a pure mandatory minimum, it just says no deferred or suspended sentence, so there would be some jail time. But it also provides an opportunity for the judge to consider mitigating circumstances. I gave the example of if there was a public employee who was either misled or compelled or pressured by an elected or a supervisor to commit some type of fraud or theft, that would be a type of mitigating circumstance, so I support it.
Is there any further discussion? Seeing none, let me just point out, Representative Wilson submitted this bill, and I thought it was a good bill, and here we are. So, I appreciate her doing that. Representative Ted Lewis, House File 2574, clerk will call the roll.
Representative Wolf.
Aye.
Representative Waller.
Aye.
Representative Wilbur.
Aye.
Representative Beckensky.
Aye.
Representative Dunlap.
Aye.
Representative Beck. Aye. Representative Petzoff.
Aye.
Representative Boardman.
Aye.
Representative Ramirez. Aye. Representative Shipley.
Aye.
Representative Treehouse. Aye. Representative Stone.
Aye.
Representative N. Thompson. Representative C. Thompson.
Aye.
Representative Watkins.
Aye.
Representative Walter Michelle. Aye. Representative Lewis.
Aye.
Representative McDowell. Representative Williams.
Aye.
Representative Wills.
Aye.
Unanimous.
With unanimous vote, House File 2574 will move to the Forest Committee bill. A few housekeeping things. First of all, I don't think this place could operate without the Hartsel girls. The pizza is because of them, and so many of us have functioned because of them, so I just have to do a shout out to them. They're pretty amazing. I would also just say, in an hour, 10 minutes, we did not get those, so we are the best committee. Thank you all for your cooperation. Thank you all for your home. If there are no further business coming before the committee, say none, Representative Russell.